Michael Bacina has flown in from Australia, one of the prominent lawyers in this space, to give us a talk on the laws of the metaverse. Welcome, Michael.
Well, good morning, everyone. Thanks so much for giving up your time this morning. You might see me hobbling around with a crutch. I'm ditching it for this talk. Now, 10 minutes is short, and there's already a clock running on a screen for me. So I wanted to make something a little bit different, so please bear with me, because I probably haven't been this nervous since I started doing talks 7 years ago. But I wanted something to give a little bit, take away, stick in your minds a little bit. And given there's so many artists here, and I don't pretend to approach the amazing art of all the fabulous fine artists here, but I thought, what better way than perhaps do a little slam poetry for you? So, without further ado, good morning, new friends here in London town. I'm honoured to be part of the experts all round. Now you might be saying, who's this lawyer from down under? What's he going to say? Is he bringing the thunder? I brought no pricing alpha. Do your own research there. But on the legal side, I can give maybe a little steer. NFTs span a whole range of laws, and learn it yourself and your head is going to be real sore. 6 years crypto lawyering, but I'm no trendsetter. I tried some ARB once, but SBF did it better. I do have some tips, so we'll go verse by verse. It's just a little rhyme on the law of the metaverse. It's an invisible world written into existence by Satoshi, not Craig. An open source persistence. Crypto winter, DeFi summer, NFT autumn spring. In the background lurks the difficult legal things. ETH and Algo, Bitcoin, IMX got the fame. They're all major projects sitting on our public blockchains. But central databases and paper, why, they're just old world comedy. We all put our faith in decentralized technology. In 13 long years since the Bitcoin white paper, and we've had our share of just a couple of dodgy capers, but if you want to get across it, then you start your traverse. You've got to get on board. It's the law of the metaverse. If you look very closely deep in the lines of code, there's no matrix control here, just unstoppable nodes. We've got transactions transparent. They're going hour by hour. Irreversible, set with Schwarzenegger power. Disruptive innovation, it's no easy feat. And legal definitions, as boring as they are, they have to be complete. Legislation and case law from 1893, well, they can't match our code-powered legitimacy. But just like Hamilton in the face of ignorance and resistance, we're all writing disruption into existence. There's so much going on. The project's wide and diverse, and then they all run into the law of the metaverse. NFTs, we've soared high, but now the floors hit the street, and none more so than Jack Dorsey's first tweet. The art might be yours, but if your docs don't behave, and some smart Alex is going to come along and right-click save. We've got Bored Apes, CryptoPunks, heaps and heaps of profile pictures. Now they're just the start, and I sure hope they made you richer. The normal rules still apply though, so when you're charged for the fame, keep clear from false reps and misleading claims. You get your promises all clear, make them true and fair. Don't end up in court over a frog's derriere. Because a project ill-considered, when it's straight up perverse, it's going to be in trouble with the law of the metaverse. And now DAOs, they're a growing source of NFT creation, and they operate just like their own tiny nation. I'm a big fan of rappers, so get some legal stability. It's a much better place than personal liability. But scams and exploits like the early DAO hack, they put regulators and politicians straight on the attack. But with Wyoming saddled up, maybe there's a solution. So when will a DAO next try to buy the US Constitution? We've got more frameworks coming like the DAO-friendly koala. Could we have legal certainty from the Shard to Sydney Harbour? It'd be welcomed. No one's averse to a bit more clarity in the law of the metaverse. And how we might feel ancient, but it's all oranges and apples. But if your project offers yield, you might soon feel the shackles. SEC, DOJ, you don't want to feel that burn. We're not going to make it if you offer passive returns. Ape in without checking the security situation. It might seem easy now, but it's classic risk creation. Facts and circumstances, the lawyers, we all sometimes sound a bit useless, but you don't want to be in front of a judge and be excuseless. Square pegs, round holes, nothing really fits. But right now, the regulators, they're not making the lifts. When they bring up compliance, they don't want to always converse. We got no neat fits in the law of the metaverse. Tax, well, it's not a pleasant trip. It's no fun excursion when accounting systems can't even handle NFT conversions. But if you change your domicile to reduce paper profits, Please watch out for His Majesty's Revenue Office. Sales tax is also hard when you don't know your customers. Are they from Brighton or Bondi? Are they honest or hustlers? Rules are coming soon, maybe coded into the sales. It would really be better if we could just focus on landing the whales. Every country's quite a bit different, makes for lots to do. And that's what lawyers are here for. Better us than you. Paying tax automatically, well, for many that wouldn't be a curse, and that's what I think is probably the future of the metaverse. Now, property law. It's straight up tricky. But when we see our bored apes adored, they've just been found to be property in the courts of Singapore. The High Court considered, they found for the ape. NFT definitions are finally starting to take legal shape. And if you're running a market, stay liquid, keep your advice on hand. You've got to learn the lessons of Cryptopia in New Zealand. Or Mt. Gox, 6 years of liquidations and court. The battles for creditors take time to be fought. Insolvency's a mess. See Celsius all frozen, 5 billion in assets. But when will the degens get chosen to get some crypto back? Do we have to wait for the back of the hearse? But be patient though, it's just the law of the metaverse. Now this is a lot to get through when you're trying to read the law. It's a lot less fun than coding, and for most it's a bore, although we choose it as a profession. So I appreciate your time listening to my little verse. It's just a rhyme on the law of the metaverse. And if you take one thing away, hodl this one close. Get into the details because they're missed by most. Give yourself lots of time. Don't be rushed and under pressure. Extra revisions will make your documents much fresher. It's old school hard work getting legal ducks in a row. You set it up clean and your project goes on with the show. Play it right, bank the ETH, and skip the shady vice. And one last thing, make sure you've got solid legal advice. Well, thank you. That's probably the most applause I've ever got for any kind of legal speech. Thank you for being a part of my first time on a crazy idea. I have a few minutes left, so I do have time for any questions from the crowd. Don't be shy now. You, sir, in the front.
Transcript of that speech.
Someone was asking me to send it off to a legal journal, but I don't know if they'll appreciate it quite so much. I don't think they know what WAGMI is. Yes, sir.
So Web3 domains like Ethereum name services are important. So Web3 domains like the ENS are important part of the metaverse because they define our identity there. It's like our names here. In some cases, they offer passive income through ENS tokens or any other. Does that also apply laws of the metaverse, and how can we be careful about that?
So do you mean the airdrop for ENS?
I mean, not the airdrop specifically, but for example, passive income that can be related to tokens, underlying tokens of these type of Web3 domains and stuff.
So what we're seeing at the moment is that DeFi protocols and completely decentralized projects which have some kind of reward or yield generation, at the moment they're in the too hard basket for a lot of regulators. They're focusing on the CeFi world and the exchanges and marketplaces where there's at least an identifiable party to sue or put cuffs on. And that's where most enforcement has focused. I do a lot of work with the Federal Treasury in Australia and touch base internationally, and it's a common thread around most of the Western countries is really the next few years we're going to see the centralized space looked at closely. So centralized projects which are paying yield are something that I think are in a lot of danger. There are ways to structure reward programs. As the panel said previously, the little hint of the efforts of others. Reward programs usually require the customer's effort in doing things to earn something in return. But when you're in that passive space of selling something where people will simply get something for free, it gets a lot more dangerous. And I think there is probably some projects and I hold some as well, NFTs, where you're given a Genesis NFT and you're going to receive every other one that ever comes out in the release. That, I think, is safer because it's a product, and NFTs are a new product, and we've been teaching regulators about that quite a bit. But I think it's when you more get into your liquidity pool style things or staking where you kick back and have percentages marked. Anytime you see a percentage or feel the urge to put a percentage in the advertising for a project, that's a good sign that the Amber Alerts should go off and it's time to ring your favorite lawyer and say, should I do this? And they'll say no. But that doesn't mean you can't frame up a reward program which is properly incentivizing people to do good things for the project and be rewarded for doing so. Now I'm 20 seconds to go. Great. So any other questions, please find me. I will be around. And otherwise, I think we'll hand over to our next speaker. Thank you so much.